Good evening. This is a surprise broadcast because we had some breaking news today, and it's a doozy. You've probably heard, if you pay any attention to anything going on in the world of trans rights, that today the United Kingdom Supreme Court issued a ruling that the media seems to be taking a very certain way, but there's a whole lot of hyperbole and static and other assorted shenanigans going on surrounding it. We need to have a look at this. Now, I just got home from work. I perused the actual court decision over my lunch break. It's 88 pages. I didn't have time to go through the whole thing, and I just got home. So we're going to take this together. I don't have a lot of time today, so I'm going to try to move fast and make some sense of this. First of all, we are live on both the Trans News channel and my main channel because I want people to actually be able to see this if they want information about this subject. So if you're joining me from Better Than Ember, do remember to subscribe to the TransPositions and Transpositive News so you can get all the trans news. Okay, with that said, let's begin with one of the articles touting what is going on. So this is the New York Times. UK top court says trans women are not legally women under Equality Act. So this is it's an intense headline, but remember that qualifier at the end, under the Equality Act. Now, for full clarification, the New York Times is not super trans positive. I don't know how this article is going to go, but there is an important qualification in here. So it says Britain's Supreme Court ruled that the word woman refers to biological sex under the country's anti-discrimination law, in a blow to trans rights activists. We will see about that. The Supreme Court in Britain ruled on Wednesday that trans women do not fall within the legal definition of women under the country's equality legislation. The landmark judgment, it's an appeal, but whatever, which said that the legal definition of a woman is based on biological sex, is a blow to campaigners for transgender rights. It could have far-reaching consequences on the operation of single-sex services, like domestic violence shelters, as well as on equal pay claims. It comes amid intense public debate over the intersection of trans rights and women's rights, which is a very strange way to phrase that, because we'll get to it. However, and this is what I wanted to put on the thumbnail because it's so important and everybody seems to be missing it in the coverage that I've been seeing so far today. However, the 5 judges involved in the ruling emphasized that they were not commenting more broadly on whether trans women are women, saying it is not the role of the court to adjudicate on the meaning of gender or sex. Instead, the judgment is limited to the precise interpretation of language in the 2010 Equality Act specifically, which aims to prevent discrimination. This decision will likely be welcome news for Prime Minister Keir Starmer. Some legal scholars have theorized that the court might refuse to rule and instead force his government to weigh in on a thorny and divisive issue, to say the least. The government said in a statement Wednesday that it had always supported the protection of single-sex spaces based on biological sex, which is problematic for a number of reasons, but I'm sure we'll probably get to that. And the ruling brought clarity and confidence around the provision of services in hospitals, domestic violence shelters, and sports clubs. What did the court say? The deputy president of the court, Lord Patrick Hodge, said on Wednesday, quote, "The unanimous decision of this court is that the terms women and sex in the Equality Act of 2010 refer to biological women and biological sex." He added, quote, "We counsel against reading this judgment as a triumph of one or more groups in our society at the expense of another. It is not." He said that trans people would continue to have protections against discrimination, but that it would be under the protected characteristic of gender reassignment rather than sex. And there is something to that, but it may not fall out the way the good Lord thinks it will. We'll get to that too. Lord Hodge described trans people as a vulnerable and often harassed minority, while noting that women had long fought for equal rights with men. Quote, "It is not the task of this court to make policy on how the interests of these groups should be protected," he added, "but to ascertain the meaning of the legislation which Parliament has enacted." Oh boy, there's something there too. Although the case was focused on the legal definition of women with regards to this one specific act, it also applies to trans men sometimes, because the Supreme Court ruled on the broader meaning of sex as being biological sex under the Equality Act. And that's a thing I don't think the Lords were thinking of in their ruling. How might this affect trans people in Britain? Legal experts said it would take time to digest the implications of the court's 88-page ruling, which is true. It's a lot. But one likely effect is that it will be easier for single-sex facilities to exclude trans people. Sort of. Under Britain's Equality Act, it was already legal for some services or facilities to be provided for one sex only under certain circumstances. For instance, assault crisis centers, changing rooms, and female-only hospital wards could be restricted to one sex, the law said, if, quote, "a person of one sex might reasonably object to the presence of a person of the opposite sex." However, many legal experts had argued that the contradictions between the Equality Act and the Gender Recognition Act of 2004, which states that a trans person with a certificate is legally of their acquired gender, it gets a little more specific than that, but that's on a separate tab. We'll get to that in a minute. A trans person with a certificate is legally of their acquired gender meant that people running single-sex facilities struggled to know if they were on the right side of the law if they excluded trans people. Here's a pro tip. Don't exclude trans people on the basis of being trans. No more than you would a cis woman who looks extra manly or with PCOS and so has facial hair growth or anything else. It's just one other characteristic that should be irrelevant, but details. The court's decision aims to clarify that. Spoiler, they did a little, but they kind of didn't. But yeah. The judges also noted that the existing equality law protected pregnant women and new mothers, but failed to offer the same rights, such as maternity leave, to trans men who became pregnant, which is true. That is a known problem in the Equalities Act. Britain's equality regulator had told the court that defining sex as biological sex would resolve this issue. Not really. The issue of single-sex bathrooms has not been as polarizing in Britain as it is in the United States, and the judges did not refer to it directly in their ruling. Less polarizing, but not without controversy, shall we say. But we don't have time to get into all of that. How is the court's decision being received? Susan Smith, the co-director of For Women Scotland, the organization of misogynistic women who brought the suit in the first place, to which this ruling is an appeal on a lower court's decision, etc., etc. She's part of the group. The activist group that had brought the legal challenge said the judgment would ensure that, quote, "services and spaces designated for women are for women," which was already true. She added, quote, "everybody should be protected by the Equality Act. This is not about prejudice or bigotry," even though it is, as some people would say. Yes, it's not about hatred for another community. Oh, really? It's just about saying that there are differences, and biology is one of those differences, and we just need protections based on that. And to an extent, there's something to that. The Equality Act, as previously noted, could have done a better job, and it definitely does need revision to account for things like trans men who need parental leave. These things are obvious because there's biological components that go beyond gender, and they do need to be considered. But that doesn't mean we have to throw everything out and it's a mess. It's a mess. Of course, Robert Galbraith had to weigh in. The creator of the Harry Potter series supported For Women Scotland in their legal campaign, by which they mean she gave them shit tons of money to keep appealing it until they eventually found judges that would give them a W, but whatever. She said she was proud of the group in a post on the app formerly known as Twitter, and claimed the case had, quote, "protected the rights of women and girls across the UK." kind of the opposite in some ways, but pop off. Groups that campaigned for trans rights expressed concern, but also appealed for a careful assessment of what the court's ruling did and did not change. And as previously stated, that will take some time. We can only skim some of the bits that I already caught in my brief glance in this episode. I'm sure other people are going to do a deep dive and a full assimilation, but I know a lot of people are worried. It doesn't say what the media says. In some ways, it's even weirder, but in other ways, it's not nearly as bad as is being portrayed, like the headline at the top of the page. My goodness. Groups that campaigned for trans rights expressed concern, but also appealed for a careful assessment. We covered that. Scottish Trans, which campaigns for gender identity rights, cautioned against misinterpreting the decision. Quote, "We'd urge people not to panic," it said in a post on social media. I agree. That's why we're here right now. There will be lots of commentary coming out quickly that is likely to deliberately overstate the impact that this decision is going to have on all trans people's lives, which is true. We've seen that all day today. Holy crap. And Sacha Desmuk, my apologies, Sacha, the chief executive of Amnesty International UK, said it would take time to analyze the full implications. Quote, "There are potentially concerning consequences for trans people, but it is important to stress that the court has been clear that trans people are protected under the Equality Act against discrimination and harassment." Yes, keep that in mind. It's not saying trans people have no protection. It's just dealing with the specific article of the specific appeal of the specific lawsuit. It's very specific, folks. However, Simon Blake, the CEO of Stonewall UK, an LGBTQ plus charity, said that the ruling, quote, "will be incredibly worrying for the trans community and all of us who support them." And again, that's why we're here. This is one thing I can do to help support people by easing worry, lowering the temperature of the conversation, and evaluating what's really there to kind of stave off some of the panic. So why did the Supreme Court weigh in? The origins of this ruling lie in a law passed by the Scottish Parliament in 2018, aiming to increase the proportion of women on government agency boards to 50%. That is what the case is about. That's all it specifically addresses. There are deeper ramifications because of the way the ruling was adjudicated, but that is the sole issue actually being directly decided by this case. This specific law passed in Scotland. As part of the legislation, the government said that trans women could count towards the target of 50% women representation, which it should, because first of all, under the Gender Recognition Act, trans women are women legally. That's the whole thing, but details. Secondly, trans women do count as women for the purposes of legislative representation, because trans women's personal issues in dealing with law and moving through society are identical to those of every other flavor of woman, because we're women. You can't say, well, we have to exclude tall women from this 50% because they're dealing with slightly different sets of issues due to being tall. That would be ridiculous. This is on par with that. It's just an adjective, folks. 4 Women Scotland took the Scottish government to court, arguing that trans women should not be included in the quotas. I think setting up a quota is probably not a great idea in the first place, but that's a whole other issue. The government amended its guidance to say that only trans women with a so-called gender recognition certificate, and this is what I mean about how the New York Times is not super trans friendly. There's no reason to throw in a so-called there. There is no reason for that at all. It's just being derisive on purpose. It is a gender recognition certificate. That's what it's called in the Gender Recognition Act, an act of UK law. That's the name of the thing. It's not so-called. It's not some people say. It's not just an opinion. It's in the actual law. But I do digress. We have not a lot of time and a lot to get through, so I'm going to keep the tangents to a minimum. Trans women with a gender recognition certificate met the definition of a woman under the Equality Act of 2010 and could therefore be included in the quotas. Gender recognition certificates are legal documents that can be granted by the British government to people who have lived in their acquired gender for 2 years and intend to do so for the rest of their life, and who have been diagnosed with gender dysphoria. The process, which has not been changed by Wednesday's ruling, grants successful applicants the right to update their sex on official documents such as birth certificates and to marry in their affirmed gender. Certified gender, but whatever. For Women Scotland continued to challenge the Scottish government in a series of court cases and eventually appealed to the Supreme Court, Britain's highest court. The court ruled in the group's favor on Wednesday. Sort of. But that's a whole separate thing. Okay, so that's what the New York Times has to say. I'm going to check in with you folks in the comments because, again, I know I'm going really, really fast here. I didn't, whatever, it's fine. Technical difficulties. Trusty Ape, hello, my unfinished journey. Good to see ya. Captive Desk, hail Bigfoot Dave. And let's see what Trusty Ape says, I saw the thumbnail and my jaw dropped. Right? It's been like that all day in like every single support group I'm a member of. People are flipping the fuck out. Wowzers. Diamara says, what's going on in the UK? It's a dystopian hellhole. Did I tell you that I'm leaving? That would probably be wise. And I mean, the US is not in great shape. The UK is in increasingly not great shape. It's an oof. It's an oof. Summer Indo on the internet sends $2. Thank you so much. And says, God wants to know if he should smite somebody. Quite possibly. But that's a whole other thing altogether. Okay, let me get the other window open here. Ryan Donovan, good to see you. Because this is a PDF, and this PDF, the actual ruling, is linked in the description of this video. So if you want to peruse it yourself, you can download the PDF and go through it at your leisure. It's in the description. Have at. But because it's a PDF, it opens in a completely different browser on my system. And again, I just got home from work. I'm going very fast. I didn't have time to mess with it. So we're just doing it in its own window. It's fine. Okay. Judgment for Women Scotland Limited. Appellant versus the Scottish ministers, the respondent. Before Lord Reed, President, Lord Hodge, Deputy President, Lord Lloyd-Jones, Lady Rose, and Lady Simler. So the entire court is all aristocrats, which is great. But I mean, there's 2 women on the court. It's something, I guess. The case was actually heard back in November, but the judgment was given today, naturally. Okay, so we've got names of involved people. Now, these are the representatives for the women's group, For Women Scotland. These are the representatives of the Scottish government. And then what they call interveners are sort of like friends of the court here in the US. They're people who are sending in information for the court to consider in addition to whatever testimony and evidence may be available. In this case, the first one listed, Sex Matters. Now, we know that one. That is a group headed, owned would be a more correct way to put it. Statter, the woman who was forced out of her job for being blatantly transphobic, a behavior which, by the way, is still illegal in the UK, but she was not fired. Her contract was not renewed. And that's an important distinction. Like Riley Gaines, she took a small speed bump for her own abhorrent behavior and built it into a massive multi-million-dollar career. She also employs a whole bunch of transphobes, not the least of which being conspiracy theorist Helen Joyce, the person who's been touring, doing the book fairs and the Oxford Literary Festival and so on and so forth. That's a whole big ball of wax, a big freaking ball of wax. We don't have time for it. Point is, this organization, a group that is specifically devoted to anti-trans conspiracy theories is involved in the case. Awesome. Another group, Scottish Lesbians, the Lesbian Project, the LGB Alliance. Now, I'm not familiar with Scottish lesbians, but the Lesbian Project is related to the LGB Alliance, as well as Get the Out and a few other anti-trans groups, specifically and expressly anti-trans groups. That's all they do, is try to hurt trans people. They don't do anything to defend the group they claim to speak for. That the Lesbian Project, for example, they don't do a damn thing to advance the interests of lesbians or increase, legal equality for lesbians. It's purely about fucking over trans people. So that's fun. Also worth noting, the LGB Alliance, some journalists got their hands on the membership rolls, and the group, for one thing, it's not as big as you might think. There's only a couple hundred people. But more importantly, 90% of their membership are hetero cis people. There aren't any LGBs or Qs or Is or As. I'm okay. There's a couple. There's a few token members, but it's like Moms for Liberty, right? There's like one mom, same sort of thing. It's not what they want you to believe it is, but that's neither here nor there. Another group, Equality and Human Rights Commission. Now that's a legit thing. That is a organization commissioned by the UK Parliament to oversee the interaction of the Equality Act with existing British law, which, if you're at all familiar, is a mess. It's centuries and centuries of precedents and rulings piled on top of each other and in conflict with each other. And it's I don't want to be a lawyer in Britain. My goodness. And another group, Amnesty International UK. We've already heard a bit from them in the New York Times thing. So we've got several openly biased, specifically dedicated, expressly anti-trans groups, a government organization, and a nonprofit dedicated to fairness and human rights. There is no expressly pro-trans group represented, but whatever. Okay, so again, this is long. We don't have much time. I'm going to go very, very fast. Lord Hodge, Lady Rose, and Lady Similar, with whom Lord Reed and Lord Lloyd Jones agree, and there's a reason they phrased it that way, because it puts two women in the three who made the decision, and then the other two men are just also agreeing. That way it's 2/3 women making the decision, even though the court's vote was unanimous. So whatever, we're propagandaing right out of the gate. Awesome. This appeal is concerned with establishing the correct interpretation of the Equality Act 2010, the EA 2010, which seeks to give statutory protection to people who are at risk of suffering from unlawful discrimination. The questions raised by this appeal directly affect women and members of the trans community. On the one hand, women have historically suffered from discrimination in our society, and since 1975 have been given statutory protection against discrimination on the ground of sex. On the other hand, the trans community is both historically and currently a vulnerable community which Parliament has more recently sought to protect by statutory provision. Basically good so far. It is not the role of the court to adjudicate on the arguments in the public domain on the meaning of gender or sex, nor is it to define the meaning of the word woman other than when it is used in the provisions of the EA 2010. It has a more limited role, which does not involve policymaking. The principal question which the court addresses on this appeal is the meaning of the words which Parliament has used in the EA 2010 in legislating to protect women and members of the trans community against discrimination. Our task, the court, is to see if these words can bear a coherent and predictable meaning within the EA 2010, consistently with the Gender Recognition Act of 2004, GRA 2004. Now, we're deviating a little bit off track here, because the lawsuit for which this is an appeal to specifically deals with the EA 2010. And here the court is bringing in the GRA. I'm sure it's totally fair play and legitimate, though. It's probably fine. You'll also note they reference a something happened in 1975, that will come up as well. As explained more fully below, the EA 2010 seeks to reduce inequality and to protect people with protected characteristics against discrimination. Point of order, the EA 2010 does not do that. Those people are already protected under law from discrimination. The EA 2010 institutes statutory regulation on penalties for that discrimination, ways it should interact with existing social systems, stuff like that. It does not directly protect against discrimination. It just offers redress for grievances when you are discriminated against. Again, I am not a full lawyer. I am definitely not a British lawyer. I'm just going with a plain reading of these things. But it's a bit of a reach. Among the people whom the EA 2010 recognizes as having protected characteristics are women, whose protected characteristic is sex, and, quote, transsexual people, whose protected characteristic is gender reassignment. Not exactly. Partly, but not exactly. The reason gender reassignment is partly protected is because it is the gender reassignment itself that leads to the position of having a legal sex distinct from the legal sex one previously had to carry around as assigned by the government. There are scenarios, and they are addressed in both of these laws, the EA 2010 and the GRA 2004, that deal with trans people who are discriminated against as the sex that they assume under the GRA, but also discrimination that they have to deal with as a result of being, as the court puts it, a transsexual. You can be discriminated against for being trans and not for being a man or a woman. That's a thing that happens quite a lot. You may be surprised, or rather, the aristocrats who made this decision may be surprised. The question for this court is a matter of statutory interpretation. Sort of. But we'll get to that. But before discussing the general approach to statutory interpretation, we set out the structure of this judgment and address the matter of terminology. We discuss terminology, the approach to statutory interpretation, and the factual background between paragraphs 6 and 35. We'll go through some of that, but again, not a lot of time today. We address the historical background to the GRA 2004, its interpretation and its operation between paragraphs 36 and 111. Now, you'll notice the paragraphs are numbered, and this is handy. It's actually super useful, and I appreciate them doing this, laying out which groups of paragraphs cover certain things. So if you're only interested in the historical background, for example, skip to paragraph 36 and go from there. We then, between paragraphs 112 and 264, address in some detail the interpretation of the EA 2010 to give its provisions a coherent and predictable meaning, and we summarize our reasoning in paragraph 265. Now, I'm going to note that because, again, we're in a hurry, not a lot of time today. So at some point, probably not too far in the future, we're going to jump to 265 and look at what that says directly. But first, a little bit of terminology, and I do want to show you part of the... Oh, it just shows you the whole screen when I click around. Of course, because I'm in a separate window. All right, while we're here, Gender Recognition Act 2004, Section 9. This will come up. So put a pin in this. Remember. Okay. Section 9 is the general part. It's a complicated act. 1. Where a full gender recognition certificate is issued to a person, the person's gender becomes for all purposes the acquired gender, so that if the acquired gender is the male gender, the person's sex becomes that of a man. If it is the female gender, the person's sex becomes that of a woman. Pretty clear, pretty unambiguous. Keep it in mind how clear it is, because that will come up. Okay, Equality Act of 2010. This is the UK laws have this really nice feature, legislation.gov.uk. You get the whole act in a layout form, and then you can click on a section of it, and it will bring up that section and show you the subsections, and it'll give you a timeline to show the changes. if there are any. I'm not seeing any actual changes, but okay, whatever. C'est la vie. This is a section 7 for gender reassignment, which will also be relevant. 1, a person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. Kind of important because that means HRT counts. 2, a reference to a transsexual person is a reference to a person who has the protected characteristic of gender reassignment. 3, in relation to the protected characteristic of gender reassignment, a reference to a person who has a particular protected characteristic is a reference to a transsexual person. A reference to persons who share a protected characteristic is a reference to transsexual persons. So this is from the EA 2010, and it talks about the characteristic of gender reassignment as being protected as a characteristic with regards to trans people. They use the term transsexual. It's 2010. It's whatever. It's language of its time, but it's for legal purposes, it's fine. But it talks about the terminology. It makes no reference to sex directly, other than the purpose of reassigning a person's sex by changing the physiological other attributes of sex. So what we need is the Gender Recognition Act to give us that legal definition that when a person gets a gender recognition certificate, legally speaking, not biologically speaking, although the Equality Act section on gender recognition does imply that there are biological changes, which is true, but this is strictly legally speaking. For legal purposes, the person's sex becomes that of what they're transitioning into. So that's important to keep in mind. Now that we've got that covered, not quite what I wanted to cover it, but it's covered. Now we have those tools and we can follow along here. Okay, terminology. We are aware of the strength of feeling which has been generated by the disagreements between campaigners seeking to represent the interests of each of these groups, and that taxonomy itself can generate controversy. We are content to draw on the terminology used by the Scottish ministers in their written case for the purpose of this judgment, and have adopted the following terms: a person who is a biological man, i.e., who was at birth of the male sex, but who has the protected characteristic of gender reassignment, is described as a trans woman. Right there, we hit a problem. Rather than delve into that, I'm going to give them the out of saying they're using the terminology they borrowed from the Scottish ministers in their legal paperwork, so it's not actually the court screw up, principle of charity, whatever. But I do want to note that's not quite right. I'm not going to spend a lot of time on it because, again, we don't have much time, but I do want to note it. Similarly, a person who has a biological woman, i.e., who was at birth of the female sex, but who has the protected characteristic of gender reassignment, is described as a trans man. We describe trans women and trans men who have obtained a gender recognition certificate, GRC, under the GRA 2004 as trans women with a GRC and trans men with a GRC, respectively, and their gender resulting from the GRC as their acquired gender or acquired sex. So you see right here, even though they are borrowing the terms from the previous papers, they are deliberately setting up to conflate gender and sex because they're saying they're interchangeable. And that's a problem, because even if they're borrowing the terminology from the Scottish papers, being a court, they should still disambiguate for the sake of correctness and accuracy. But no, they don't do that. Just noting it, we're moving along. We also use the expression of biological sex, which is used widely, including in the judgments of the Court of Session, to describe the sex of the person at birth, and we use the expression certificated sex to describe the sex attained by the acquisition of a GRC. That's a little problematical, but whatever. We got to move on. The legislation with which this appeal is principally concerned is the EA 2010. Yes, it is. Will they stick to it? No, they won't. And we address the effect, if any, the GRA 2004 has on the interpretation of the terms sex, man, woman, male, female used in the EA 2010. The central question on this appeal is whether the EA 2010 treats a trans woman with a GRC as a woman for all purposes within the scope of its provisions, or when the Act speaks of a woman and sex, it is referring to a biological woman and biological sex. See, that I get that they're using the terms of the Scottish people, but that still bugs the hell out of me because woman is not a biological term and trans people are biological. We're still made of flesh and blood. We're meat robots. We're not robots. It just The general approach to statutory interpretation in the United Kingdom is well established. The House of Lords and this court have set out the basic approach on a number of occasions, including a bunch of cases. Quoting from one of those cases, the court in conducting statutory interpretation are seeking the meaning of the words which Parliament used. And that goes back to the 1975 case that they referenced earlier. And there's a reason they go all the way back to 1975. I don't know if we're going to get to it. So for the sake of brevity, it's because there's very specific language that they can then cherry pick and try to bring forth into the future, even though subsequent laws and decisions have abrogated those definitions. They're trying to cherry pick a specific outcome. Of course they are. C'est la vie. Okay, let's... Again, not much time. In fact, I'm already running a little bit long. So I'm going to jump ahead to one area that stood out to me, paragraph 245. Again, the link to this PDF is in the description on both channels, so feel free to help yourself. I need to go a lot faster if I want to get to paragraph 245. Where is it? 217. We're getting close. Paragraph 245. This has to do with the armed forces. Schedule 9, paragraph 4 of the EA 2010 provides for 1, a person does not contravene section 39(1)(a) or (c) or 2(b) by applying in relation to service in the armed forces a relevant requirement. It does matter here. If the person shows that the application is a proportionate means of ensuring the combat effectiveness of the armed forces, a relevant requirement is A, a requirement to be a man, B, a requirement to not be a transsexual person. So the law specifically lays out a distinction that is inclusive and specific. It disambiguates between what they're calling biological sex and gender. And more importantly, it does not differentiate between a person with a gender recognition certificate and without. It's because that's an issue, which we will get to in the conclusion. 3, this part of the Act, and so far as relating to age or disability, does not apply to service in the armed forces in Section 55. So far as relating to disability does not apply to work experience in the armed forces. I don't know why they included that one. That one doesn't really matter. 246. Although we accept that the dual requirement of not being a man, so there's a typo because it says right here, a relevant requirement is a requirement to be a man. So there's errors in this ruling. Did they proofread? They spent months on this. Did they actually proofread? Pretty sus. Let's mentally correct that. Although, if there's one typo, there's likely others. There may be other places where not is missing and should be there, or is there and shouldn't be. So we may have a reverse polarity negation situation in other parts of this document as well. If they made this error in one place, it very likely happens in other places. Telling which, who the hell knows? Which is why making sure your shit is on point is important. Especially when you're like the highest court in the land and your rulings are sort of important. Whatever. Although we accept the dual requirement of being a man and not being transsexual means that this provision can operate effectively on a certificated sex basis. It operates just as effectively adopting a biological sex interpretation. No, it does not operate just as effectively. See, this is the thing. They're making the case that if they reinterpret the Equality Act of 2010, which specifically refers to sex and gender distinctly, but they're saying, no, we need to take this thing and we need to throw out gender and refer only to assigned sex at birth for the purposes of the specific provisions being questioned in this one specific law. We need to make it only be biological sex. But they're looking at other sections of the law, like Schedule 9, Paragraph 4, relating to military service. That's not part of the, it's beyond the scope of the lawsuit, but details. But also, they're trying to cram their preferred interpretation into the law to show how it would work, and they're bungling it because they're taking a clear section where it disambiguates and makes very, very clear that it's talking about both being a man in the terms of male and not be transsexual, as in assigned male at birth. It works. If you change it to being only on a certificate, the legal sex, having a gender recognition certificate, then it's repeating itself. It doesn't actually help. It doesn't do any bloody good. It makes it overcomplicated and will make a reader scratch their head and go, why did they say this twice? So no, it does not work just as effectively. It makes it cumbersome, and it shows the errors in the thinking. It creates the very problem the court is complaining about, that sections become less clear. But whatever. Unlike the inner house, we do not consider that it supports a certificated sex interpretation accordingly. See, this is another big problem, and a reason I brought us to this section, because it shows some of the problems, 3 huge problems in this ruling right here in this one paragraph. The not that shouldn't be there, which denotes there are other errors elsewhere in the thing. This claim that using a biological only interpretation is just as effective, and it's not. And then, unlike the inner house, we do not consider that it supports a certificated sex interpretation accordingly. That's the third error. First, they say it will work just as well. And then the very next sentence, they say the alternate prevailing upheld definition that exists in statute and case law is not as good. They say that it does not support that interpretation, even though the preceding sentence they said either interpretation works just as well. They're leading a decision with non sequiturs, huge leaps in logic. They're just asserting shit at this point, and it drives me fucking crazy. But whatever. The EHRC's recognition of problems in their interpretation of sex as certified sex, and this is the Equal Human Rights Commission, that body that we mentioned before, that was commissioned by Parliament to oversee the implementation of the Equality Act of 2010, to which this case directly pertains. They're the agency, if you will, in charge of administering the act. And they filed what we would call briefs with the court to show some of the ways that a biology-only ruling would interact with the law. And here's some of what they had to say. The EHRC is the expert agency tasked by Parliament with considering the operation of the EA 2010. In its letter of 3rd April 2023, the EHRC advised the UK government about the consequences for broader functioning of the EA 2010 if the decision of the Lord Ordinary in For Women Scotland versus Scottish Ministers was upheld, as it was in large part by the Inner House. A lot of that has to do with the way the British court system is set up. Some things are done by courts, and some things are trials or hearings held by governmental bodies rather than courts. It's sort of like having to go to the Senate to stand trial rather than the courts. It's complicated. England is very, very complicated. It is not for the EHRC to determine the meaning of sex in the EA 2010. That is literally what they're supposed to do, but whatever. That is for the courts to do. Now, remember what they said in the beginning about how they were saying their job is not to interpret the law broadly, or to create new policy, or to redefine words. Their job is only to decide the correct interpretation in this one specific application of one specific group of terminology in one specific case. But now they're saying, no, it's not for the parliament created commission whose job is to do this. This is for the courts to do. Is it the lack of proofreading, or is it that they lied up front? They said, no, we're going to do our jobs. And then later on, way down here in paragraph 247 on page 76, now they're saying, no, we're taking this power. This is ours now. However, we consider it significant that many of the problems we have identified as leading to incoherence and absurdity in the practical operation of the EA 2010, if a certificated sex interpretation is adopted, that's a weird if, because that's already the case. That is, according to the GRA 2004, what the law says. Very plainly says. We just looked at it. It's very clear. It's very unambiguous. It's plain language. And the Equality Act 2010 being written, proposed, passed, adopted, enacted after the GRA 2004 includes the GRA 2004 in its underlying legal foundation. So yes, the EA 2010, if a certificated sex interpretation is adopted, what do you mean adopted? That's what it's based on. But whatever. Are expressly recognized by the EHRC as grounds for urgent consideration of legislative amendment. Now, what this overly complicated, massively verbose sentence is saying is that maybe the legislators should get to work and pass some laws to clarify this shit, which may be good advice. Although I'm not sure if I'd trust the current British government to do it. Whatever. The letter explains the EHRC's understanding that sex in the EA 2010 has a certificated sex meaning pursuant to sections 9.1 and 2 of the GRA 2004, which we just covered earlier. TLDR, yes, that is what it says. It is very plain. In fact, we can look at it again. It's right over here. The person's gender becomes for all purposes the acquired gender, so that if the acquired gender is the male gender, the person's sex becomes that of a man. And if the female gender, the person's sex becomes that of a woman. Yes, for legal purposes, because it's a law. That's what it does. That's what it means. That's what it is. It's pretty dang clear. And continues that, quote, it has not been straightforward for the service providers and employers to apply the law, including in areas such as sport and health services. Yes and no. It has been relatively straightforward when people operate under good faith, but there have been a number of bad faith actors who have gone out of their way to deliberately misinterpret things and cause controversy. And that's where the issues start to come from. Like Sex Matters and the LGB Alliance and so on and so forth. The EHRC concludes that, quote, if sex is defined as a biological sex for the purposes of EA 2010, this would bring greater legal clarity in 8 areas. The areas are then discussed as follows. 1, pregnancy and maternity. As things stand, protections in the EA 2010 for pregnant women and new mothers fail to cover trans men who are pregnant and whose legal sex is male. Defining sex as biological would resolve this issue. Yes. Now, what this is talking about is, like we discussed at the beginning of this broadcast, how trans men, for example, have a much more difficult time getting parental leave when they've just given birth. That's a problem. That's an oversight in the law. However, the court taking it unto itself to rewrite whole sections of British law, which are not under the purview of this case, may not be the best way to do that. But yeah, that is an issue. And that is one thing that would be improved, not fixed, but improved under this reinterpretation. And it is a reinterpretation because, again, the GRA is very, very clear. This is a pulled out of whole cloth, cherry picked from past laws, preferred interpretation, not based on existing statute. But whatever. 2, freedom of association for lesbians and gay men. If sex means legal sex, then sexual orientation changes on acquiring a GRC. Do you have a legal sexual orientation? Is that a legal thing in the UK? Let's, for the sake of charity, assume that it is. Some trans women with a GRC become legally lesbian, and some trans men with a GRC become gay men. Legally, as things stand, a lesbian support group, for instance, may have to admit a trans woman with a GRC attracted to women without a GRC, or to trans women who had obtained a GRC. On the biological definition, it could restrict membership to biological women. Well, I don't know how clubs and associations work, or even support groups in the UK. I don't know if they are legally required to admit anyone who asks and meets the qualifications. If that's the case, then maybe that's a law that should be looked at. My understanding here in the United States is that clubs tend to be voluntary groups, and so they tend to allow only in the people whom they want to allow in, regardless of how a person qualifies or what have you. But I'm sure it's more complicated than that. There are some issues with this, but I don't want to get too hung up on this because, again, limited time and I'm taking way too dang long. Freedom of association for women and men. As things stand, a women's book club, for instance, may have to admit a trans woman who had obtained a GRC. See, this may have to admit. What does that mean? Are women's book clubs compulsory in the UK? Why is this a matter for law? Like, I mean, there are women's book clubs here in the US who admit cis men because it's just, there's no legal requirement that the members have to be women, right? It's like baby showers here in the US, at least, are traditionally attended mostly by women, but sometimes cis men come and no one cares. It's fine, you know? What is the problem here? Additionally, trans people aren't just legally members of their acquired sex. There are pretty significant biological changes that come along with transition, although there are differences in the ways one goes about transition, and a trans person should not have to medicalize to any degree according to statute, right? Trans healthcare exists to alleviate discomfort and help you live a better life, the same as all the rest of healthcare. It does not mean that you have to do things in order to check boxes in order to meet a legal obligation, which is why we've been seeing things like the GRA come up, which remove requirements for effectively mandatory sterilization. That shit's not cool. And as we discussed earlier, sometimes trans people still have babies. Some people want to do that and also be the gender they are. That should not be a problem, but apparently it is. Positive action. Currently, trans women with a GRC could benefit from women-only shortlists and other measures aimed at increasing female participation. That is the actual point of this case. Remember, if you're joining us late and you missed it, the entire reason this ruling exists is because the Scottish Parliament wanted to increase women participation, and so they set a goal of 50% women. And then the transphobic, misogynistic conspiracy theory groups funded by J.K. Rowling threw a shit fit and said, well, trans women shouldn't count towards that 50%. That's what this is. This buried here, way in the bottom, is the entire fucking reason for this case. But okay. Trans men with a GRC could not. A biological definition of sex would correct this perceived anomaly. Now, that's not a positive action. That is not a positive action, because in the context of the 50% participation from the Scottish Parliament that this case is actually about, If you change it to a biological definition of sex, then that means trans men count as women for the purposes of women's participation in the government. You want to talk about incoherent consequences? Holy shit. This is the women's rights group literally handing women's spaces to men who do not want to be there. No one wants this, but this is the inevitable consequence of this so-called positive action. What the actual fuck? Number 5, occupational requirements. Employers are sometimes permitted to restrict positions to women or to men. An employer can, for example, require that a warden in a women's or girls' hostel be female. At present, such a role would be open to trans women with a GRC, but not to a trans man with a GRC. A biological definition of sex would correct this perceived anomaly. Same issue. There is nothing wrong. There is nothing wrong with a transitioned trans woman filling this position if she's qualified. That's what should matter, is if she's qualified, but whatever. However, a trans man with a GRC filling this position, because a biological definition of sex, is a huge problem. What are you doing? You're a fucking court and you want to put a man in charge of a women's prison and call it resolving perceived anomalies. Wild. They're not thinking of the consequences at all. They're saying, this is what we want. Fuck what's actually going to happen. We're just going to declare things. Single sex and separate sex services. Service providers are sometimes permitted to offer services to the sexes separately or to one sex only. For instance, a hospital might run several women-only wards. At present, the starting point is that a trans woman with a GRC can access a women's-only space. The service provider would have to conduct a careful balancing exercise to justify excluding all trans women. Yes, as they should. Just as they would have to get very creative in order to justify excluding all Black women or all Muslim women or any other minority group of women that you might think, oh, we need to keep them out of a pretty spaces. Like, what are you doing? This is the language you're choosing to use is blatantly prejudiced. It's bigotry right there on the page. Why would you want to exclude all trans women? I could see possibly someone wanting to exclude trans women with certain characteristics that makes it inappropriate for them to be in that specific location, depending on the purpose of the location. There could be a case made for that. I would challenge you to hell and back to justify that case, but I will allow the possibility that a case could be made. But to exclude all trans women is flat out bigotry. Nothing but bigotry right there on the page in the official Supreme Court ruling. What are you doing, United Kingdom? A biological definition of sex would make it simpler to make a women's only ward space for biological women. Technically true, but what are the other consequences of that? Again, you'd have trans men in there. In fact, you'd be forcing trans men in there. A trans man who just gave birth needs very different health care from a cis woman who just gave birth, because the physiology is different. And also, if you're worried about the comfort of the other women in the ward, sticking a whole ass man in there is not the way to resolve that situation. Sports. Because this is totally within the realm of this case. My goodness. At present, to exclude trans women with a GRC from women's sports, the organizers must show that it was necessary to do so in the interest of fairness or safety, as they should before excluding any eligible potential participant. A biological definition of sex would mean that organizers could exclude trans women from women's sports without this additional burden. Is that a positive, though? Is that something that you really want to happen? Because if you're just excluding whole groups of women without the additional burden of having to justify why you're excluding them, you might run into some fallout. There may be some knock-on effects from that. Perhaps. Data collection. When the data are broken down by legal and not biological sex, the results may seriously distort or impoverish our understanding of social and medical phenomena. A biological definition of sex would require public bodies like universities to apply this category without the complexity added by a legal definition of sex to the analysis of data collected in fulfilling the public sector equality duty. And therein lies a problem, because a trans person in most circumstances of life experiences interaction with society in virtually every respect as the gender they are. So what's the problem? The only potential issue I can see is with reference to medical phenomena. But here's the rub. Medical data is already collected with a distinction. There has to be a distinction, whether you're collecting legal men and legal women or females and males or whatever it is you're collecting, you already have to distinguish trans members because their data is going to be different in many, many, many circumstances. So yeah, that's a thing that's already done in medicine, and the change in the law that this ruling proposes will not alter that. It's wild. There are 3 areas identified by the EHRC where it suggests that a change to a biological sex interpretation would be more ambiguous or potentially disadvantageous. The things we just read are supposedly the pluses. Holy shit. Equal pay provisions. At present, a trans woman with a JRC can bring an equal pay claim by citing a legally male comparator who is paid more. A trans man with a JRC could not. The proposed biological definition would reverse this situation. This effect would be to transfer this right from some trans women to some trans men. That's ambiguous. That's potentially disadvantageous. That's complicated. In what universe is one man being paid less than another man a problem for an equal pay provision on the basis of sex? Like, what are we doing here? Direct sex discrimination. At present, a trans woman with a JRC can bring a claim of direct sex discrimination as a woman. A trans man with a JRC could not. The proposed biological definition would reverse the situation. The effect would be to transfer the right from some trans women to some trans men. And that's another problem, because if you're a woman and you're being discriminated against because you're a woman, regardless of whether you're cis or trans, then it's because you're a woman. You know, it's a tautology. It's axiomatic. Like, what are we doing? We're trying to set up a situation where a trans man would have to file a claim of being discriminated against as a woman. Not only is this incoherent, but it also kind of borks the whole point. You know, it makes things needlessly complicated, outs people against their will for the purposes of legal proceedings. Not that the UK seems to have an issue doing that, given several of the stories going on. This could go on for some time, as you can imagine. Again, not a lot of time. I've already gone longer than I want. Let's skip ahead to the conclusions. So, that is paragraph 265. See, I made a note from before, and we're almost there. 264? Where's 265? Okay. Summary of our reasoning. Is it just the summary? Oh, summary of the EA 2010. Okay. Summary of our reasoning. We are aware that this is a long judgment. It may assist, therefore, if we summarize our reasoning. The question for the court is a question of statutory interpretation. We're concerned with the meaning of the provisions of the EA 2010 in light of Section 9 of the GRA, paragraph 2, which we covered earlier. But once again, the person's sex becomes that of a man if trans male. If the female gender, the person's sex becomes that of a woman. Super clear, super concise. Your legal sex is the thing you're transitioning to, legally speaking. Super easy, barely an inconvenience. Parliament, in using the words man and woman in the SDA 1975, referred to biological sex. Where did that come from? Remember what I mentioned earlier? They're drawing shit from 1975 because they're cherry picking their freaking definitions. Now, it may well be that there is some relevance covered in paragraphs 36 to 51. Again, big caveat, I've only had a chance to scan through this on my lunch break because yay capitalism. But why are we going to a completely different law outside of the scope of this thing to draw definitions from 1975, literally 50 years ago, when the laws that are being discussed, EA 2010 and GRA 2004, have definitions of sex in them and make no reference that I've seen to this 1975 case? Why are we doing that? Unless we're deliberately trying to skew the case. 3, the 1999 regulations, again, outside of the scope of this case, enacted in response to P versus S, created a new protected characteristic of a person intending to undergo or undergoing or having undergone gender reassignment. The 1999 regulations did not amend the meaning of man or woman in the SDA 1975, which is one of the reasons the GRA 2004 was necessary. The GRA 2004 did not amend the meaning of man and woman in the SDA 1975. I'll give them partial credit. They're kind of building a case for why we should consider this 1975 thing. I'll give them that. They're kind of building a thing. Section 9.3 of the GRA 2004, which isn't relevant to the case, disapplies the rule in Section 9.1 of that act where the words of the legislation enacted before or after the commencement of the GRA 2004 are on careful consideration interpreted in their context and having regard to their purpose to be inconsistent. This is the summary, folks. Inconsistent with that rule. It is not necessary that there are express words disapplying the rule in Section 9.1 of the GRA 2004, or that such disapplication arises by necessary implication. Holy shit, as the legality principle does not apply. Okay, Section 3. Subsection 1 is subject to provision made by this act or any enactment or any subordinate legislation. That's what it says. It's saying that the first section, where your legal sex becomes the gender you're transitioning into for legal purposes. All it says is that this section is subject to provision made by this act or other enactment or subordinate legislation. It's saying that the rest of this law and other subsequent laws apply. That's all it says. What are we doing here? What is this? Holy crap. In the context of the EA 2010 was enacted, in the context in which the EA 2010 was enacted and was therefore that the SDA 1975 definitions of man and woman referred to biological sex and trans people had the protected characteristic of gender assignment. Maybe I'm very tired, but that sentence didn't seem to make any sense. The context in which the EA 2010 was enacted was therefore that the SDA 1975 definitions of man and woman referred to biological sex. That doesn't track. The context that this law was enacted in is therefore, because Section 3 says that Section 1 doesn't apply to 1975, therefore the rules are 1975. Whatever. And trans people had the protected characteristic of gender assignment. The EA 2010 is an amending and consolidating statute. It enacts group-based protections against discrimination on the grounds of sex and gender reassignment and imposes duties of positive action. So thing about the EA 2010 is it does not only guarantee certain statutory protections, but it also imposes certain positive action duties, particularly upon government. The government must do this, the government must do that, in order to ensure greater equality for people of every protected characteristic, not just gender. And that may be why it's relevant to this case, because, again, the original reason for the case is the ministers of Scotland wanted to have their board be made of 50% women. Pretty simple, straightforward thing. But no, we're making a whole thing about it. But okay. It is important that the EA 2010 is interpreted in a clear and consistent way, I agree, so that groups which share a protected characteristic can be identified by those on whom the Act imposes obligations so that they can perform those obligations in a practical way. Right. Which is why we should stick with the pretty clear and concise definitions that are already in those laws, instead of imposing our own based on ideology influenced by known hate groups. But maybe I'm asking for too much. There is no indication in relevant secondary materials that the EA 2010 modified in any material way the meaning of man and woman or sex from the meanings in the SDA 1975. We would have to review the SDA 1975 in order to compare. I'm not going to do that tonight. I don't know that this is relevant, though. Interpreting sex as certified sex would cut across the definitions of man and woman and thus the protected characteristics of sex in an incoherent way. Yes and no. It would cut across those definitions, and in some certain circumstances, it would create an incoherency, but that's one of the reasons that we don't interpret sex as distinct from certificated sex, right? This is a legal concept that's been brought in by layers of legislation. It's, again, it's a mess. Using the very simple criteria laid out in the Gender Recognition Act, it removes all of this baggage. Just use the law that's already there instead of trying to impose your own prejudice and bias onto it and creating even greater incoherencies and absurdities. It would create heterogeneous groupings. As a matter of ordinary language, the provisions relating to sex discrimination, especially those relating to pregnancy and maternity, and to the protections from risks specifically affecting women, can only be interpreted as referring to biological sex. Yes and no. Again, trans people assume many of the characteristics of the sex they're transitioning into, depending on how they go about the process of transition. It's a very complicated topic, and it is best left to medicine, but since law has to decide some of these things and they need to put people into groups for the purposes of head counts, it gets messy. You're going to have some intersectionality. You're going to have some cutting across definitions because these are complex groups. Multifaceted groups. You got to deal with it. But the existing law is very simple and very clear. And adding this extra layer not only interferes with the simple function of those existing statutes, but creates a whole new ball of nonsense. I agree with the court that there are problems with the EA 2010, with the GRA 2004, problems that result in trans men who give birth being unable to easily access parental leave the same way a cis woman who gives birth does. There needs to be more work done. But setting this situation where we're just going to punch this bullet hole through existing law and fuck everything up is not a great answer. The court has demonstrated that their reasoning is flawed. Their rationale is riddled with errors of both the logical and actual typographical variety, and that there is a powerful bias driving this. That said, they're not entirely incorrect. As previously stated, there does need to be additional refinement within the law, but as the court said at the beginning and then recanted later, this is properly the work of the legislature, and inserting their own preferred terminology does not make things better. Net effect. Again, this ruling only pertains to the specific case that was brought, the appeal, which was against the ministers of Scotland who wanted to be able to count women as women for the purposes of a goal of having 50% women's participation. The antagonistic group, the For Women Scotland, they said, no, we don't want trans women counted. We want trans men counted as women because it's so much more coherent. That was the case. That's what the ruling decides. For Women Scotland from the British Supreme Court is correct. They ruled them correct. They are legally correct. They're technically correct, which I'm told is the best kind of correct. Therefore, the Scottish Parliament must count trans men as women and may not count trans women as women for the purposes of that 50% membership goal. That is it. That is all that this ruling specifically does. However, the implication, the fear, is that the reasoning in this ruling will be used to effectively justify basically a complete void of the Gender Recognition Act, rendering all gender recognition certificates null and void, because sex is purely what you were assigned at birth, regardless of anything else from a legal context. First of all, this ruling does not apply universally to the UK. It only applies to the appeal that was specifically being ruled on. So please bear that in mind. Second, there is something to be said for what's been said here. I mean, I've criticized the hell out of it, but there is one thing the court got right. There is a difference in rights between trans people with a GRC and trans people without a GRC. And not everyone can get a GRC. It's easier than it has been in previous years, but it still has a tremendous amount of gatekeeping that creates a barrier some people just cannot cross. And that's a problem because it creates a two-tiered system of trans people. Some trans people who are legally recognized and other trans people who aren't. That's an issue. And this ruling points at that issue. So it's not all bad either. It's pretty damn bad, but it's not all bad. There is a silver lining. But whether you consider that significant or not, the good news is this. Much like the cast review, the bias is right out there in the open for anyone to see. Again, the PDF, the actual ruling, linked in the description on both channels. And it does only apply directly to the specific case, that Scottish Parliament goal of having 50% women membership. That is all. And considering the potentially catastrophic outcomes if this pile of bullshit were applied universally, that's some pretty good news. I've gone on a lot longer than I intended to, but this is so fucking important. And I hope it helped some of you get your mind wrapped around this, figure out what the hell is going on, and have a less shitty day. Thanks everybody so much for joining. Again, this is a live broadcast. I just got home from work before I hopped on the air, but it's so fucking important. I appreciate y'all stopping by. Hello, future people. If you're watching this in replay, remember to hit the subscribe button, because I do go live spontaneously sometimes, and sometimes it's pretty damn important. But again, thank you so much for watching. Thank you for joining. And tune in tomorrow for Transpositions news on the Transpositions here on YouTube, because we have some good news for you. Good night.